Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Hi, everybody. My name is Beth Rappaport. I'm with Campbell Property Management. Campbell has been in business since 1953, and today we serve over 450 associations in South Florida. Today's webinar is about the topic of Florida homestead law and owner's increase in the basis of your property. We hope you enjoy it. It's a little bit more of an advanced financial topic. And some of it is directly related to the association, and some of it pertains to questions that we do get on a regular basis, and we welcome the opportunity to address it here today. A little bit about Bill. Bill's with Stroemer and Company. He's our speaker today. He is a member of the National Association of Enrolled Agents. He's also very involved with the FICPA. And he serves on the CIRA community committee. The CIRA stands for Common Interest Realty Association, which is what accountants call our communities. He's a certified enrolled agent, and he has 35 years public accounting experience. Stroemer is a full service CPA firm, and they are peer reviewed. Here's a disclaimer that's important for you to read that basically says that this seminar does not constitute professional advice, and you should seek your own advice for your own personal matters. Here's an outline of what we're going to cover today. So basically, we're going to talk about Florida homestead law, which is often very misunderstood, and then we're going to talk about the owner's increase in the basis of your property for condos, HOAs, and co-ops. And in today's audience, we do have about 2/3 condos, 1/3 HOA, and we do have a few co-op people in the audience, but the information in today's seminar is the same regardless of the housing type you are inquiring about. I would like to now turn it over to Bill to give us a quick overview of Florida homestead law and the importance for full-time Florida state residents.
Hey, good afternoon, everyone. Glad that you joined this presentation. Beth, that's a great question. And what happens is the Florida homestead law provides real property tax relief and breaks to homeowners who treat their Florida residents as their principal residence, meaning that's where they're considering their house that they live in and day out. For example, Trump, owns and now considers his principal residence as Mar-a-Lago and no longer Trump Towers in New York City. He's on Palm Beach Island. We also have Sylvester Stallone now calls Florida his home. He was in California. So the point is here, you can become homesteaded here in Florida, no matter what your income level is, and be able to take advantage of what the homestead law is. In addition, snowbirds can also take advantage of the Florida homestead laws, providing they make Florida their principal residence, spend over 6 months a year here, and affirm to the property officials here that this is your principal residence. So,
Bill, thank you. Yeah, thank you. That is so helpful.
Yeah. So what you can do, if you're interested and you're not already homesteaded, you can go to the Palm Beach Property Appraiser's website to see what you need to do to qualify, and it's fairly simple. So let's.
Perfect. And yeah, and part of why we're addressing this today is we have so many residents living in our communities that have moved in over the past couple of years that do have a lot of questions for their property managers. Because whatever state they came from might not do things the same way. And so we felt it was important to address some of these questions and answer them in today's seminar.
Right. So principally the homestead exemption, it provides protection so that a Florida property owner can't lose their primary residence to a judgment. And so there's 4 exceptions to the homestead protection. And we can put that on at the end for the slide. It basically protects you against losing your property, but for these 4 area segments. In order to obtain the homestead exemption, you have to file Form DR 501, and you can do that via paper or online with the property appraiser's office by March 1st. It only applies to individuals who own their property or own their unit and not the common area value of the property. So what typically happens here in Florida is, how do you determine that? Well, what happens is when you buy your property here in Florida, a copy of the closing document gets submitted to the property appraiser's office, and that becomes the starting point for the fair market value and what you're going to be taxed on in terms of real property. The benefits of filing for the homestead election is really twofold, and this is really what the nice part about it is. The homeowners who qualify are entitled to a $50,000 reduction in their assessed property value, and an owner that's homesteaded will not see an increase of more than 3% per year in their taxable value, no matter how much the market value of the home increases, and that limits your real estate tax bill to no more than 3%. So when you first purchase property here in Florida, the county property assessor's appraiser's office records your purchase price that you paid as you're assessed from the closing statement, and that becomes the starting point for what you're going to be taxed on. In Florida, it's a little bit different than some of the other states in that every January 1st, the county appraiser's office reappraises your property value based on recent sales of similar property that has closed within the past year. So what they're going to do is, if you bought your house this year for $300,000, on January 1st, they're going to look at similar properties and potentially change your appraised value in the event that it went up in this next year. So it's something that's fairly important to look at, and it actually impacts your property tax bill. For example, several years back, when the Florida market property was really hot, people that had purchased in the 2010 to 2015 period really came down here and were able to buy places for reasonable prices. And with the influx of people within the past 7 to 10 years, those prices for those that are new down here to Florida have gone tripled, double and tripled. And so if you had become homesteaded here in Florida, it would have greatly reduced your potential tax bill from basically a 3% increase per year to maybe 3 times what you paid for it. So it's pretty remarkable to see if you can apply and become homesteaded here in Florida. You're going to need to provide certain documents when you make your application, such as a Florida's driver's license, as proof of what your Florida residency is. So
thank you, Bill. And just a reminder, we will be sending out a copy of the presentation and the slides later today, not to worry. And just changing gears a little bit, Bill, can you talk to us about changes emanating from the recent election?
Yeah, so they actually sweetened the deal as a result of this past election here in Florida. There was Amendment 5, which actually came in and provided for an annual increase in that 50,000 exemption based on the cost of living increase, or the consumer price index, if you will. And so effective 1/1/25, we're going to see what that $50,000 assessed value subtraction that you get jumps up to. The other important thing to note is you're going to say, well, I moved down here and now I want to find a different place. The homestead exemption is portable, so it goes with you if you sell and move to a new residence. All you have to do is go refile with the appraiser's office, and they'll move that homestead exemption from your prior property to your new property. One of the other things that I want to talk about that is also available to people as of recently is there's a free property tax alert that a lot of the counties in Florida have set up. And what it does is it protects your property from fraudulent activities. I don't know if people have gone on TV and seen some of the ads for LifeLock and the others where people go in and they basically file false documents with the appraiser's office, and they go out and get a loan on your property, and you don't find that out until they default. And so what's happened is that they've began a program where you can file with the clerk of the circuit court and controllers in Palm Beach County, as well as some of the other counties. And what that will do will be to give you notification in the event that somebody tries to change title to the property with the property appraiser's office. And so it'll stop the criminals from gaining title to your property fraudulently. Pretty important. It's a free process, and it's something that everyone should consider taking a look at. There's a website, sign up for the fraud. It's an easy 5-minute set of questions that you have. And basically within a 48-hour period, they will notify you if anybody comes in and tries to take your property. The other point that I want to make as well too is that housing co-op owners technically own shares of stock in the corporation. They don't necessarily own the property per se. So for example, if you were a co-op owner in New York, the property taxes would be paid by the co-op itself, because that's where the property is basically registered with, it's on that corporation's books. But down here in Florida, because they want to give people that opportunity, it doesn't make a difference whether or not you're a co-op owner, a condo owner, or an HOA owner. You can take advantage of the homestead exemption. And you'll be able to see, actually you could get on to see right now, if you go to the property appraiser's website and do a search and type in your name or your property address, and you'll be able to see you come up with what the statistics are on your fair market value of the property, what exemption amount you would get, and what your taxes are. And it actually goes out to the previous 10 years. So if you're interested in tracking what your tax increases were, or your tax bills, you can go ahead and do that. One of the other interesting portions to this as well is there's some condominiums, for example, where the manager units, they're manager units, so they're not owned by the owner. And so you won't see those on the property tax rolls, because common area property isn't subject to tax in Florida. So that's something just as a fact. So if you see a particular condo that doesn't have it, it's normally because it's been on there as a manager unit. Associations do have the ability to foreclose on homestead properties. You really need to go consult your attorney for further details if you do get in arrears, and there is some sort of foreclosure process. Your attorney will be able to tell you what your rights are and basically how to proceed.
And Bill, let's change topics now and start talking about the tax basis of your property. Why is it important to monitor the tax basis of your property?
It's important because today what's happening is, and especially in the condo world that are within the Cirrus world, you're getting fairly big assessments for reserves to replace the roof, do the concrete work and the like. And basically every time that there's a special assessment, or you're funding the quarterly invoice for your reserves, that potentially goes to increase your basis in your home's property. And why is that important? It's important because what's going to happen is if you go to sell, you're going to want to know what your basis is. And your basis basically is going to be increased for every reserve assessment or special assessment that went to fund a future capital expenditure, because under the IRS rules, that becomes basis in your property. So it's going to, in effect, help you in the event that you do want to sell, whether or not it's your principal residence or not, because it's going to go to reduce that potential gain that you would otherwise pay on your property. So it's important that you look at and track what your basis in your property is, and we're going to get into more of that as we go along with the presentation. The one other important piece of this is that in the event that you've decided that you're not going to sell, but you're going to will that to a family member or someone else as a beneficiary in your will, that person will get title to the property. And in that particular case, that tracking that basis currently, right now, doesn't make any difference, because upon your passing, that property gets stepped up to the fair market value on the date of that person's passing. So that's an important thing to also know as well. Outside of that, you need to track your basis. So when you buy a home in a community association, and this is whether it's a condo, an HOA, or a co-op, you're essentially paying the price, but the price that you're paying really includes a piece of the common area. So for example, I live in an HOA and I bought my house, but in that value that I paid for that house is a portion of the common area. And when you get a special assessment for future capital projects, it's really for common area property. So you're actually paying for the improvement and or the renewal of that common area property. So that's an important thing to understand. So as I said, some of the funding, whether it's the quarterly or a special assessment, so normally what'll happen is you may have two types of assessments where the board will come in and do a quarterly assessment based on what their reserve studies are or the pooling method is. And then you might get special assessments for situations where they may want to do an improvement in the pool or the tennis courts or the pickleball courts or whatever it might be. And that at that time that special assessment is passed, that also would potentially go to increase your basis as well. So the basis really needs to be tracked from the date that you purchased the property. So if you purchased it, for example, we'll just do a little numbers explanation here. So if you purchased your unit or your home for $300,000 on January 1st, then that becomes your starting point for your basis. Your basis then is increased by any capital expenditures that come through as a special assessment or as part of the quarterly invoicing for the reserves. So that's something that you need to track. That's the starting point for your tracking of the capital contributions, is when that first time after you've purchased the property. So this is going to go, as I said before, to increase your basis and thus reduce the tax gain that you would otherwise have on the property. Okay, so your basis, when we talk about that, is going to equate to, as we said, the original purchase price. We did as an example, 300,000 plus the capital improvements that were made during your period of ownership. So in your particular unit or your house, you might have gotten the kitchen redone, you might have gotten the bathroom redone, any type of capital expenditure to your residence or your unit has to also be tracked, because that's going to increase the basis of your house, along with the capital contributions that we just talked about during your period of ownership in the unit or the property. Very important to keep that on some sort of schedule that will show what the amounts were when it came in, so that when you do go to sell, you'll be able to properly calculate what your basis is. So right now, the way the tax law is right now, you're going to be subject to a long-term capital gains tax that could be up to 23.8%, because that's what it is right now from the Tax Cuts and Jobs Act. If it's in Florida here and you're a resident of Florida, of course, you don't pay any state income tax, which is a great thing. If it's your vacation home down here in Florida, obviously it's going to help you on your federal return, and you'll have to consult your tax advisor as to the impact it would be on your state return in the place that you're domiciled. The important thing to also understand, if you own a home in an age-restricted community, 55 or older, there are no changes to how this tax basis is handled. So it really, you'd be subject to the tax whether you were 55 and over or not, and it doesn't matter that you're in a 55 or older unit here in Florida.
Thank you, Bill. And what is the best practice for tracking the tax basis of a property?
Well, the best practice is you're going to keep the closing schedule from your purchase docs. You're going to keep track as to the improvements that you made in your own unit or your home. And then you're going to look to see the portion of your special assessments and reserve fundings that relate to the capital expenditures. So here we're going to do a little bit of a deeper dive into that, because what you would look at in terms of the assessments is normally on the audit report that you receive from your CPA firm. But there are certain situations and adjustments that need to be made from what's published on the reserve funding schedule within the audited financial statements. And so what's going to happen is that you're going to want to potentially look to your board of directors or your association to potentially track what would be the amount that would be subject to your capital contribution as an owner, because not everything that's funded qualifies for treatment as that. So one of the other points that I also want to make as well, and this is to the board of directors and to the members as well, is that when the special assessments are funded and the reserve is funded, those amounts, in order to make them capital contributions for the owners, need to be put into a bank account that's separate from the operating income. Very, very important, because it's not only that in the docs you're going to show that the contributions are for future capital improvements, but more importantly, it's not commingled with the operating bank accounts. It's got to be put into a separate bank account. It's got to be stipulated that it's only for future capital expenditures in order for it to qualify for the owner as the increase in their basis. Okay? The other note here is, if it is your principal residence down here in Florida, the other thing that you do need to know is that you potentially could be able to take an exclusion on the gain when you go to sell the property. Right now, there's a gain exclusion of $500,000 if you're married filing joint, and $250,000 that you would get if you were single. So you really do need to go out to your tax pro that's doing your personal return. This is by way of explanation so that you make some notes to yourself so that when that time comes, you can be accumulating this information and not necessarily be in the dark as to scrambling to find out what your basis is. So one of the things that we want to get into a little bit more that I just alluded to was the capital expenditures. As I said, there's some requirements and on the tax side that you need to be aware of. And you might need to do some data mining in order to be able to understand what your particular association's piece is going to be for capital expenditures. Typically, in reserve funding, you have sometimes a component for painting. You might have a component in that reserve for contingencies. You might have a component in that reserve for deferred maintenance. You may have a component for insurance deductible. Anything that's within that special assessment and/or reserve funding that's not for a future capital expenditure, and it's not considered a capital expenditures, which are the items that I just discussed, don't go to increase your basis. So you need to make sure that you look into either have your firm that's preparing your tax return take up this project where they can go in and look at the components of what made up the reserve contributions for that year or the special assessment and adjust for those items that would not be considered future capital expenditures. We've done a number of studies going back to developer turnover where we've tracked what those capital expenditures are for on a tax basis for the owners, and that's something that you may want to consider. Recently, I did one where they had ongoing reserve assessments, but they decided to build a restaurant and a bar, and they took out a special assessment for another $25 million. That was some significant dollars, and obviously the owners want to make sure that they basically track that so that if they decided to sell, they would make sure that they wouldn't be paying tax on something that they didn't have to. The second piece of that that's probably equally important, besides obviously not paying the tax, is to know what that impact is on the value of what your property is as well, too. So if anyone's interested out there, we can give you some more information on the capital contributions end of it. But basically, we're talking about those items as painting, contingencies, deferred maintenance, insurance deductible. And so those items have really come into the forefront and are usually some big ticket items now, especially with the insurance deductible going up because of the insurance premiums. So the other caveat to this whole thing here is that this segment is not intended to provide tax advice, because you've really got to engage your tax advisor, okay, by providing him or her with the information in terms of the basis, and they will do the calculation and make any adjustments that they need to. So we're not acting in this capacity as a tax advisor. We're merely alerting you to what the opportunities are.
Thank you, Bill. That was very helpful. Now we're going to take some questions. We have had some questions from the audience. One question we had that came in as a write-in was regarding Bitcoin, and if the reserves can be invested using Bitcoin.
Yeah, actually, you can invest in Bitcoin. It's highly discouraged. There's basically two things that a lot of the auditors and certain people that are on the boards don't want to do. That's number one, invest in securities. And the other is Bitcoin, because there's an opportunity that you're going to lose. The mandated approach usually that's strong-armed is to put those into some sort of CD or perhaps treasury bill or the like, in lieu of Bitcoin or some sort of financial products.
Okay. And then another question is, in homeowners associations that collect capital contributions at the time of purchase, does the capital contribution become part of the new owner's tax basis?
Yeah, this is another nuance that's really important. I'm glad that you asked that question, Beth. And that is that the timing of when you as an owner become responsible for that special assessment or that reserve funding is at the time that it's passed, not necessarily when it's funded or when it appears on the financial statements. So if they passed a special assessment on December 31st that was going to be funded at some point in that next year, you as an owner are on the hook for that as of December 31st, because that's the date that the special assessment was passed. Very important. Those are some of the nuances, and that's why you really just can't take the number that might be on the financial statement because of these different nuances.
Thank you, Bill. And we've got kind of a multi-part question. If a condo building has a new roof and the unit owner's share of the hurricane special assessment is covered by her insurance carrier under the loss assessment, then her share of the roof will increase the value, but will the reimbursement by the insurance carrier reduce the value?
No, normally what happens is if there's any payment coming from an insurance policy, covering a unit that's covered by insurance, it's not a taxable event.
Okay, thank you. And is the amount of quarterly fees that go towards reserve funding added to the basis?
Generally, yes, but once again, to the extent you have, say you have, you're using the pooling method. This is probably a pretty good example. You're using the pooling method, which, has components to it. It might have the roof, it might have paving, it might have painting and the like. What happens is that someone is going to need, usually your tax professional is going to need to go into the components of determining what that funding was and pull out those items that I just talked about. So if, for example, you've got a portion of that pooling is for a piece that goes to painting or deferred maintenance, that's got to be pulled out from that amount because that, once again, doesn't qualify. Typically, what happens is, let's go back for 1 minute and just talk about the capital assessment. Typically, a capital assessment is usually in an amount over $10,000, although it could be lower. But it's for an expenditure that either is replacement and or new. There's a distinction that the IRS has between what a capital expenditure is versus an operating expense item. An operating expense item might be a repair, for example, that doesn't extend the life of the asset, but it merely puts it back into working order. So that's why in that particular case, they wouldn't, the IRS doesn't consider that as an amount that would go toward a capital expenditure. But certainly, for example, if you're going to need to have concrete work done now, and they're replacing some of the rebar and the concrete as a result of that project, that absolutely would be a capital expenditure. Replacing the roof would be a capital expenditure as well. Paving would be a capital expenditure. But there are some component pieces, and that's why it's important that when you go in, for example, with pooling or you're using a component method, that you look at what those components are and make sure that you determine whether or not they're capital or not and qualify.
Okay. And why are painting and waterproofing not considered improvement?
Yeah, this has been a question that's gone on for years. The IRS came out probably about 15 or 20 years ago, even though I know that there are people that are still disputing it now with the paint becoming waterproof and everything else. But the painting is really considered and viewed by the IRS as a maintenance item, even though it could really reach over, say, $10,000 in cost. Their view is that it's a maintenance item and not something that's a capital expenditure, and they specifically have that as a no-no.
Okay, very good. And are the capital expenditure dollars collected for the HOA that affect the basis used as a deductible versus the gain after the set exclusion is deducted?
Okay, can you repeat the last part of that again?
Yes. So are the capital expenditure dollars collected for the HOA that would impact the basis, are they perhaps used as a deductible from any gain?
Yes, it is. It becomes part of your basis, and thus it does reduce your gain. Yes, that's exactly the point. So to take a math example, if for a chance you purchased a residence for $300,000, you put $50,000 in as improvements in your kitchen and your bathroom, and you had capital contributions of another $100,000, that would then go to increase your basis to 450. And if you sold the house for $500,000 or the unit for $500,000, you potentially would only have a $50,000 gain. Whereas if you hadn't considered those capital expenditures, increasing your basis, then obviously your gain would have been the difference between the 350 and the 500,000. So that's a real life example.
Okay, wonderful. And if somebody bought a primary residence in 1980, but then rented out the property for a few years and then returned to the property, making it their primary residence again, what would the basis be calculated on? The original purchase price or the date of return to the primary residence?
Well, typically, if you're basically, like we stated in the beginning, it's portable. What they're going to do is they're going to track that, and the property assessor's office is going to move that value with you as you go to the new property. If it wasn't your primary if it was your primary residence, and then you basically gave up that homestead, it would likely be whatever the fair market value is on the date again that you decided to begin homesteading again, or you qualified to become homesteaded. Like, for example, in my particular case, it was a situation where I actually closed on the purchase of my home in April. So I missed that March 1st. What happened is the property assessor's office put the house on their tax rolls based on the closing statement that I had. But on January 1st, they basically revalued it and said, hey, listen, it's closed, the sale is closed within the last 12 months. We're going to equate it to that as a starting point. So potentially, even though I purchased it, after that assessment value, in that next year, because it was an actual close within the past 12 months, they entered the purchase price and the initial value at what I paid on the closing statement.
Okay, thank you. Let's see. Does current year reserve funding for capital projects through regular dues and or special assessments that is not spent in the current year in addition to basis? Or does the funding have to be spent before the amount can be added to basis?
No, the funding does not, it bears nothing in terms of the capital improvement, because there's basically two things that have happened, and this was way even before these changes have taken place. It's basically, according to tax law, the day that the special assessment is passed is when you have a legal obligation to basically fund that. So the IRS doesn't care that it doesn't get funded in that next year or the year after, because that assessment is on the books, nor do they necessarily care that it might not be paid out for 5 years. The rule that they go on is that they look to see what the special assessment or the funding represented. So if the special assessment has to basically say it's for future capital expenditure, then the IRS condones that as being good basis at the time that it's passed. So the fact that it doesn't get spent for the next 5 years, you could have a project, for example, where you funded the quarterly reserves for a roof redo in 10 years and you're doing year by year. In that particular case, you might not, actually have the expenditure until 12 years out. But the whole deal is that the monies have been put into a special account aside from the operating, only for capital expenditures, and it thus qualifies as a basis number for the owner, the unit owner, or the homeowner.
Okay, thank you. And regarding which types of items are applicable, the plumbing waste pipes have reached the end of their life. We will be relining those pipes in place. This will extend their life substantially. Is that considered to be a capital expense that impacts the basis?
I would say yes, that's not maintenance because you're basically relining it. It would be equivalent to a situation where you were repairing the concrete and the steel rebar on the exterior of the building. Well, it's not a complete replacement. It's extending the life of it, and basically it's considered a capital expenditure.
Okay, great. Let's see. And is a special assessment required for the capital expenditure to be eligible for raising the basis? Or can usual HOA payments that are for capital expenses be considered for adding to the basis?
It's the latter, but once again, I mean, you've got to look at what the components are for that assessment to make sure that the amounts are actually for qualified capital expenditures, future capital expenditures.
Okay, thank you. Let's see. Is there a capital gain flat rate that you don't pay taxes on?
Yeah, I think if your income, they basically have 3 tiers, and I should know what the tier amounts are. Right now, if you have a certain taxable income level, I believe it's below 15,000, there is no tax on any capital gains, and then it jumps from 0 to 15 to 20%. And I'm not sure I remember correctly what the income level is for the 20%, although I should. And then the other point is when you do get up to the 20%, there's also a 3.8% tax. So that's why the total amount subject to tax is really going to be the 23.8. That is something, and that came out of the Trump's tax bill back in 2017, and it basically has been in there, and it's supposed to sunset in 24. We're going to stand by on that because, right now he's just coming in, and according to everything that I'm reading, it's basically going to remain the same, but for a few tweaks. One thing that we're hearing out there is potentially, this is going to be, once again, with individuals, if you're married filing joint, they're going to increase that $10,000 state and local tax deduction up to 20,000. So if you've got property taxes that are, say, $15,000, in these past years, you've been limited to take 10. If you're married filing joint now and it's 15, they're looking to increase that up to a $20,000 amount. Once again, it's only speculation at this point, but from what I understand, it's one of the things that they're looking at in terms of the new bill that is perhaps going to come out for the taxes. But right now, the 23%, the 0, 15, 20, and the 3.8% are still in effect for right now. We've also had, and we've also done some associations that asked us to go back and do a capital study, contribution study, going back to the point in which you had developer turnover. And there were some owners who had sold in the past 3 years that actually, after that was completed, are looking to go back and potentially amend their tax return to lower the gain. So there's normally a 3-year look back that you can amend your individual return. So, in this particular case, there was quite a bit of a special assessment, like I said, of about 25 million. And so it was something that the prior owners definitely wanted to take advantage of.
Okay. And as board members, should board members track the portion of reserves that qualify, or should they really leave that up to homeowners and their tax advisors?
The board of directors, if they think it's worthwhile for the owners, should have their firm, their accounting firm, do tracking, and then with the caveat that the firm would do the qualification of the amounts that would be considered capital contributions, but that it would be incumbent upon the owners providing that information to their tax service provider in taking it into account for their subsequent tax return should they sell.
Okay, thank you. And we've got a co-op question. If the co-op refinances a loan and uses the funding to cover reserve items due to not having the reserve funding in place, how will that impact the individual owner basis?
So the first part of that is what is it again?
Well, I'm not sure this is either here nor there. If the co-op refinances a loan and uses the funding to cover reserve items. So basically a loan is covering reserve items. How would that impact the individual unit owner or shareholders basis?
I don't know that it would, because it's not emanating from a special assessment or reserve funding. They're just taking those proceeds and using them toward a capital expenditure. So they theoretically would get the deduction for the interest on that loan and the like. So I don't know that would have a direct impact on the owners.
Okay. And is pool furniture considered an eligible capital expenditure?
I would say yes if it's over $10,000.
And that would be $10,000 for a special piece or collectively?
Probably collectively.
Okay. Okay. And if the HOA paid for a new golf cart out of pooled reserves, is this something that is eligible to impact the tax basis?
I guess if it once again if it exceeds that $10,000, I would say probably yes.
Okay, very good.
Because
And yeah,
technically speaking, and here's my line of thought on that. Technically speaking, it would be common the cart would be common area property, the same with the pool. And so, as long as you can get past that uh capital expenditure piece, it would qualify. And that's neither of those two things are maintenance items. And so, you know, that $10,000 is usually the, the base for what's considered a capital expenditure is usually $10,000 or more. But I think in that particular case, those two items, I could imagine pool furniture costing an aggregate over $10,000, and perhaps I haven't bought a golf cart, but I'm assuming that that would be a capital asset normally.
okay, perfect. Thank you. And another question, if the regular assessments include reserves over time, will the basis not increase until the work is done? So I think you've answered that basically it happens when it's collected.
It's when it's passed, yes.
Perfect. And the date that it's passed, not even when it's collected.
Correct.
Okay. And if any improvements are done using insurance claim money, how does that impact the basis?
That's not going to impact it at all because um, insurance proceeds puts back the structure to, pre-hurricane or whatever, pre-damage. And so that would not have any impact whatsoever.
Okay, and then kind of a similar related question. If an owner has a pipe burst in their kitchen and files an insurance claim, and
I Beth, you're not, I can't hear you. You're on mute.
sorry about that, somebody muted me.
Oh,
If an owner has a pipe burst in their kitchen, files an insurance claim to replace or repair the damages, and then the funds used for the repairs and the replacements, does that increase the basis?
no.
Okay. Okay. And a question about selling a house. Is it true that a portion of the sale of a house is exempt from taxation?
Yeah, I think that what they're referring to is the 250/$500,000 exclusion if it's your primary residence. So if you've computed the gain and it's five or under, you wouldn't pay any tax. If it was over five, it would be whatever piece of it is over 500. If you're single or had a household, it would still be the 250. So that I think that's what they're getting at.
Okay. And if somebody wanted to go back and research, if they've been paying HOA dues for a long time, and they wanted to know what percentages or dollar amounts have gone to increase their basis because part of the HOA goes towards the reserves, is that something they should ask the manager, or should they ask the association CPA, or how would they go about gathering that data?
They would ask the association CPA. So it works out a little bit differently usually. If you're a homeowners association, it's usually based on the number of homes that are in the association. If you go to a condo or potentially a co-op, it's usually predicated on the amount of shares or the square footage of what your unit is to the totals, is what you get allocated. So
Okay,
that's
thank
so
you.
that's why so that's why, for example, if if you had a condominium, you basically would need the association to come up with the schedule to find out what your ownership percentage is in order to be able to take and calculate what your portion is of that special assessment or that reserve is for the year. The other, I mean, if you have a situation, for example, where you're given a special assessment and you're subsequently invoiced for it, well, that would suffice, you know, being able to use that information. But typically, the reserve funding would be something where you really need the association to go back and provide you with, that ownership percentage.
Okay, thank you. And as we wind down, it looks like we've just got a couple more questions. So one of the questions we have is, let's say you are eligible to homestead. Is there any reason you might not want to?
Honestly, I can't think of any. Only because of the fact that, I've been homesteaded now since 2013, and the increase in my property taxes has only been 3% year over year. So why would you want, to give that up, simply because of the fact that, the tax rates are definitely going to continue to go up, not go down, for services. And so, the only other variable that you can really, use to tamp it down would be that 3% limitation. And it's a good thing.
Okay, and we've got a final question. Let's say you inherit a home that is your primary residence. Does that require a recalculation of your property tax assessment?
Typically, what'll happen is, I think the short answer to that question would be yes, because if you were willed that property, the title would change from whoever willed it to you to your name. And the appraiser would look at what that fair market value would be, because that's what your basis is going to be for tax purposes, on the date of passing. Not the date that the title passed, but the date of that person's passing. And so normally, depending on the amount of the home, you may engage somebody to do a valuation for it. You might ask the assessor's office, once again, as they do it on 1/1, to come up with a value. You could go back in effect to the association and ask them what, other homes have closed at that are similar in property. So there's a number of different ways that you can do it. But at the end of the day, it's going to be titled under your name, and you're going to need to provide some sort of fair market value that the appraiser will take.
Okay, and I'm not sure, this is a little bit detailed, but if you were an owner in common with right of survivorship, would that change that any? As far as the fair market value?
No, actually, what typically happens is if you're, filing joint, the value of everything just basically transfers over to the remaining spouse.
Okay, thank you.
And
Thank you,
unless
Bill.
unless
Yeah.
unless there's, I mean, unless there's something in local law, that's different. Typically that's what happens. So for example, if you had a joint bank account with your spouse and you passed, the bank account still remains the same. It's just in the spouse's name because, that's the right of survivorship.
Okay, thank you, Bill. Truly appreciate it. Thank you for all of your time today and the questions and answers. And of course, we will be sending out the presentation and a copy of the recording to everybody who attended. And please, just a friendly reminder that this does not constitute advice. This is for discussion purposes only. And we recommend that you consult your professionals, your association attorneys, tax professionals, local county property appraiser's office, and so forth for specifics about exactly where you live and specifics to your particular situation. But we really appreciate everyone's time today. Thank you so much for joining us. And we look forward to seeing you again on a future webinar.
Thanks for watching. For more great educational content, click the subscribe button now.